talking about regulation of free speech and religious liberty, and how our current doctrines may or may not affect economic distributive justice. And so he and Eugene are going to have a conversation, or I suspect they'll agree and disagree on a number of points, focusing mostly on the free speech portion of Nelson's new article. Because we're hosting this event tomorrow as part of UT's recognition of Free Speech Week, which I didn't know existed until a month ago, but we've been scrambling now to put together some events for it. And so that'll be good. If you're interested, Jordan, I can send you the link. I think it'll be a great conversation. Yeah. Okay. I'll fire it off after we're done.
Nelson is my co-author these days, so I've just talked to him a little bit about tomorrow.
Oh, good. Well,
he's a great guy. Well, both of them are. Both Eugene and him are great guys.
Yeah, Nelson's my co-author, and Eugene's I'm a chronic visitor at UCLA Law, and Eugene's my colleague there. So.
Well, that's great if you get to travel between UT and UCLA. Those are two great campuses to have to commute between or visit between.
They're good campuses and good faculties. I'm very much attracted. The law and philosophy people at UCLA are just over the top good and really interesting and good friends. So, and it's not a bad part of the world when it's not burning.
Right.
So do we see the audience in the webinar situation, or how does that work?
No, there's no video for the attendees, but the attendees are able to submit questions through the Q&A feature down at the bottom. So that's how we'll kind of facilitate that communication. And we'll get started in just a couple minutes. I'm just going to wait a little bit, see if any more stragglers trickle in.
And so Kylie, just to make sure I'm clear on this, I'll see the questions pop up in the Q&A, and then I'll just reframe them for Larry and Jordan.
Yeah, that's perfect. So when questions are submitted, you'll see little red numbers pop up in the bottom. And if you just click on that chat feature, you should be able to see them. And it'll show open questions, and then it'll give you the option to mark them as answered or dismissed as we kind of go through them. And that way you can read them, ask them as is. If they need to be reframed, do that as well. This feature just allows us to kind of filter things a little more and having people on camera.
Right. Great.
Here, I'm going to tell my wife to keep the dog away from the door. So excuse me one moment.
Or you could both let your dogs in, and we'll make it a debate over whose dog.
Let them have at it.
Yeah.
I don't know. I think there was a religious liberty roundtable meeting this summer, and somehow or another, I didn't remember to mute when I should have. And it's perfectly clear that my dogs were enormously disruptive at one session. It's terrible.
You know, I was supposed to attend all that when it was going to be held in person. And then I was literally driving across the country to come here right when that was being hosted. And so I didn't get to join.
Yeah, I've been involved in the roundtable for a long time, and it's a pretty interesting group with a lot of young people, and it's been pretty. It's been a serious, interesting project by those guys.
Yeah, I think it's wonderful.
Let's go ahead and get started. Hi, everyone. We're so happy to have you with us for another Federalist Society debate. My name is Kylie Kopp, and I'm one of our speakers chairs, and I am so pleased to welcome you guys to our discussion about Fulton versus City of Philadelphia and its implications for Employment Division v. Smith and religious liberty moving forward. For those of you who are familiar with the Federalist Society, it's great to have you with us again. And for those of you who are new to FedSoc or are joining us for the first time, we're so glad to have you. If you'd like to become a member or learn more about our organization, please reach out to Henry Humphreys, our membership chair, via the information that'll be dropped in the chat. The way this debate is going to be structured, we're going to have Professor Collis, our moderator, speak for about 5 minutes about Fulton and Employment Division v. Smith. And then we're going to allow Mr. Lorence 5 to 10 minutes to speak, and then Professor Sager 5 to 10 minutes to respond. And then we're going to save the last 30 minutes or so for Q&A. So as our speakers are talking, please feel free to submit questions via the Q&A function throughout the entire time. Welcome any and all questions. The more questions, the better for our discussion. So I'd like to go ahead and get started by introducing our speakers. Professor Steven Collis is our moderator this afternoon and is the founding faculty director of Texas Law's Beck-Laughlin First Amendment Center and of the Law and Religion Clinic. On the topic of religious freedom law, he is a sought-after speaker to both academic and lay audiences across the United States. He's been interviewed and quoted in various news and media outlets, and his scholarly work has been cited by justices on the U.S. Supreme Court and has appeared in numerous law reviews. Jordan Lorence serves as Senior Counsel and Director of Strategic Engagement with Alliance Defending Freedom. Mr. Lawrence's work has encompassed a broad range of litigation with a primary focus on religious liberty, free speech, student privacy, and the First Amendment freedoms of public university students and professors. Mr. Lorence has also argued several cases before the U.S. Supreme Court. Our own Professor Lawrence Sager is the Alice Jane Drysdale Sheffield Regents Chair and one of the nation's most preeminent constitutional theorists and scholars. Professor Sager came to Texas from NYU Law and has also taught at Harvard, Princeton, Boston University, UCLA, and the University of Michigan. So without further ado, I'd like to go ahead and give it away to Professor Collis. Go ahead and get started.
Well, thank you so much, Kylie, and thank you to Professor Sager and Mr. Lawrence for the debate, and to the Federalist Society for hosting this. I think these are very important issues we'll be discussing, and I was tasked with trying to set the groundwork for what the debate will be about so that our attendees can follow the conversation. For those who aren't familiar with the religion clauses of the Constitution, the one that we'll primarily be debating today is often referred to as the Free Exercise Clause. Larry and Jordan, I'll warn you right now, I'm going to be giving 60 years of history in about 5 minutes. So I suspect there's potential disagreement you may have with the specifics of something I say. Feel free to point that out in your comments. But just to help our attendees understand the debate itself, generally speaking, there was, by around the time about 1990, there was at least a somewhat broad understanding that if government burdened someone's religious exercise, then the Free Exercise Clause of the First Amendment to the federal Constitution would kick in, and government would have to pass the compelling interest test. And the case went up to the Supreme Court after bouncing around back and forth to the court and down and up again, where the question became whether or not Oregon, which had passed a law criminalizing the use of peyote, whether or not Oregon could pass the compelling interest test when that law burdened the religious exercise of a man named Al Smith. What happened then, everyone was debating the question of whether or not Oregon could survive the compelling interest test. Most people assumed that was the test that applied, and the Supreme Court issued a decision in the Smith case that effectively changed the law. And in a 5-4 opinion authored by Justice Scalia, the Supreme Court ruled that if a law is neutral and generally applicable, then whether or not it burdens religious exercise if it burdens religious exercise, that is not going to trigger strict scrutiny. Instead, all government has to do is survive a rational basis review. So the court did not define in Smith what it meant by neutral and generally applicable law. That is something that has been debated and worked out for the next 30 years. But it's a question that is constantly getting analyzed and reanalyzed. And ever since Smith, scholars and courts and lawmakers have been debating and trying to figure out precisely what the law should be governing the free exercise of religion. So along comes this case, Fulton versus City of Philadelphia, That involves the question of whether the city of Philadelphia violated the free exercise clause of the Constitution by refusing to allow Catholic social services to participate in its foster care system to a certain degree because of Catholic social services refusal to place foster children in the homes of same-sex married couples. That's a very oversimplification of the case, but that's what's happening there. This debate today is not going to focus on the merits of Fulton per se. The merits in Fulton, much of it are being debated or are being decided under the Smith test. So they're trying to determine if the city of Philadelphia's policy is neutral and generally applicable. The justices are also looking at some free speech arguments. But one thing the court did that was a little bit surprising to a lot of people is when it granted cert, it asked whether or not the court should revisit the Smith decision from 1990. That's going to be the central focus of the debate today between Professor Sager and Mr. Lorence. And revisiting Smith doesn't necessarily mean overruling Smith. It could mean that Smith should be overruled and the court should return to the test that was in place prior to Smith. Although I think that's going to require the justices to actually clearly define that. It could mean replacing Smith with something else entirely, or it could mean keeping Smith, but offering clarity regarding what neutral and generally applicable actually means. All of those things are on the table if the court revisits Smith. And Professor Sager and Mr. Lorence are going to share their arguments and ideas for whether or not the court should revisit Smith, and if so, how and what it should do. So with that very brief introduction and 60-year history, I'm now going to turn the mic over to Professor Sager for his, I guess, opening arguments, and then Mr. Lorence will get his rebuttal. And as Kylie said, please put your questions as they are making their points into the Q&A. I will do my best to curate those, and we'll give them all a chance to respond to them as we progress. Professor Sager.
Steve, I think we agreed that Jordan would get the chance to go first.
That's
and that I'd reply. And he represents the petitioner, and I think he ought to have the opportunity to proceed first.
Okay, well, thank you. And if you can't hear me, somebody raise their hand or inform me. I was in the courtroom in 1990 when Justice Scalia read Employment Division v. Smith. And if you're wondering, I was 10 years old at the time, if you're looking at my youthful appearance. No, not really. But I was in the courtroom, and everyone was shocked that nobody anticipated this very broad decision that basically said, if a law is neutral on its face about religion and is generally applicable, you can't bring a free exercise claim to it. And I think that that's wrong as a matter of the text of the Constitution, the original understanding, and it just has not played out very well. The text protects the free exercise of religion. So there is conduct connected to religious practice that will sometimes run afoul of some general governmental law that it has that doesn't say anything about religion. We saw examples of this at the very beginning of the Republic with the Quakers refusing to take an oath, so help me God, in the courtroom before they testified, or participating in mandatory military draft, et cetera, because they were religious pacifists. And we've seen that go on through the years. And the Supreme Court recently had a case where Arkansas prison said nobody can wear a beard unless you have a medical condition. And then Muslims who did it for religious reasons sued and won. But under Smith, now they won because of a federal statute, but if they were under only the free exercise clause, they would have lost. So I think that this has proven over and over again to just be too narrow, too cramped, and not protecting of religious liberty. What they had before, and which I think that they could go back to, which they've had under RFRA, is to protect, there's a 4-part test, which is basically somebody has sincere religious beliefs that are substantially burdened by the government. That's 2. The government can basically require the religious adherent to obey if they have a compelling state interest done in the least restrictive means. And so that is not an automatic get out of jail free card. It is a defense. And that 4-part system, think of it as a filtering system that basically allows the good cases to go forward and the bad cases not to be done. It's not an automatic get out of jail free card. If it were, the most popular church in town would be the church that teaches it's a sin to pay taxes. And federal RFRA, that has just never been, which has the exact same test, the Federal Religious Freedom Restoration Act has not had that. Now, let me just speak for a few moments about Fulton. It is surprising to me that the Supreme Court took this question of whether to overrule Smith in such a highly charged culture war case as Fulton versus City of Philadelphia. They had some other cases, including one where a guy objected to submitting his Social Security number with building construction bids to the state of Idaho. They required you to submit a Social Security number, and he believed that that was the mark of the Antichrist and didn't want to do it. They could have taken that case and also dealt with whether Smith should be overruled, but they didn't. They took this one. Now, one of the things that I would add is I think that the Supreme Court tends, I just want to offer an opinion here from reading through the briefs and all of this. They don't have to get to Smith if they don't want to. They have two grounds that I see where they could just, they could decide. I mean, they could affirm, which would, I think, not be very helpful for religious liberty general. But if the Catholic Social Services win, in this case, just to make it clear, the City of Philadelphia cut off Catholic Social Services from placing foster kids with families that they have evaluated through their home studies because they would not evaluate and certify unmarried couples, either same-sex or opposite sex, or married married same-sex couples because of their religious beliefs. And that sounds like they should use, so that's just outright discrimination. But I think that they can either win by saying there's a lot of hostile anti-Catholic statements that were made by various Philadelphia officials during this, just like in Masterpiece Cake Shop. Or they can say that there is a lot of discretion and individualized exemptions that are made by both the city and these agencies that so they do not have an across-the-board blanket prohibition on discrimination. Let me just give you some examples of this. So how the system works is for about 150 years before, since Revolutionary War times and 150 years later, the Catholic Church in Philadelphia took care of orphans. And about 50 years ago, the City of Philadelphia stepped in to regulate the system. And they realized that if they had to both take children who are being abused and neglected and then find homes for them, they'd be overwhelmed. So they have contracted with 30 private providers to basically, what happens is the city will say, we have a kid, this is the specifics on the kid. Do any of you 30 providers have families that they can go with? And they look through the list that they've certified and they send in, and the City of Philadelphia makes a decision on how they get them. Now, the City of Philadelphia can take race into consideration. It can, of the child, it can take, and of the family, it can take in the marital status, etc., things like that, whether they speak Spanish or don't speak Spanish, etc., etc. All these factors that are prohibited by their anti-discrimination policy are things that the city basically does. And the providers, understanding this, try to present families. They go through all the families and try to pick ones that would meet the needs of the best interest of the kids. Now, what has happened with all of this, and I just want to make sure my time is, I'm doing okay with that, is these 30 entities have spontaneously selected themselves to specialize in such a way, and I'll describe that more fully, where every child gets placed, no same-sex couple is discriminated against, and the Catholic Church is allowed to keep its religious convictions. So what happens is and this is from testimony that the City of Philadelphia said was that these 30 agencies will decide to specialize. For example, they will focus on a specific geographic area of the city. They'll focus on children with disabilities or other special needs. They will focus on children that speak a specific language that's not English, like Spanish-speaking homes. They will focus on, these agencies will focus on pregnant teens who are minors, pregnant with another minor. So there's some special consideration. Native Americans children have special considerations because of federal law and treaty obligations, etc. And so these agencies, if they get somebody who doesn't fit their criteria, they'll refer them to another agency. So what has happened is the spontaneous self-selection, and the Catholic Church would say, we will send, if we have never gotten a same-sex couple, but if we did, we'd refer them to one of the 3 agencies, and probably more, but there's been 3 that have been certified by the Human Rights Campaign for their exemplary servicing and evaluating of same-sex couples. So now this system has all worked out where, again, all children are taken care of. There's no same-sex couple is denied, and the Catholic Church, the Catholic Social Services, has their beliefs protected. And the city of Philadelphia has come in and disrupted this by basically saying one size fits all, but we're not even going to stand by our own standards with all this. I can see the Supreme Court saying, because there's these individualized exceptions that the city operates in itself and allows these providers to do, that they're going to go off on those grounds and not touch Smith.
So thank you, Jordan. Are you, does that mean you're?
Yes, I'm done. I'm sorry. Yes, I'm done. I'm sure
Okay.
there'll be plenty of Q&A to go into after that.
Great. Professor Sager, your response.
Okay, we're going to have to decide whether we're talking about Smith or talking about Fulton, but I want to begin with Smith.
Let me, if I could just comment on that, I do think I want to keep the discussion on Smith and whether or not that should be revisited, but I do think it's fair to give you a chance to respond to his Fulton specific comments. So please feel free to do that during your remarks now.
Yeah, well, let's begin with Smith. And I have to say, Steve, that as you anticipated, I'm going to rather strongly disagree with history, the history you set forward, or at least annotate it. As soon as Smith was decided, a good friend and colleague of mine at UT announced that religious freedom would never be the same. It would never be the religious liberty that we knew in the United States, given what Scalia had done in Smith. In the next term, immediately after Smith, a unanimous Supreme Court held that the Santeria faith had a constitutional right to engage in animal sacrifice in Hialeah, a city which had set itself firmly against animal sacrifice and firmly against the Santeria. Now, how it is that religious freedom suddenly was revived in light of Smith is pretty straightforward. Religious liberty in the United States has always been at its most robust and viable and coherent when it was equal liberty, when it was an insistence that people would not suffer because of their religious beliefs. What Smith laid to rest was not equal liberty. What Smith laid to rest was the idea that merely because someone is motivated by religious faith, they have a special claim to autonomy. Not an absolute claim to an autonomy, but a claim that any interference with their projects is unconstitutional unless it's justified by a compelling state interest. Now, Scalia did not announce that he was changing the law. He announced that he was following the law, and his argument was actually very compelling. Where did the idea that a religiously motivated person has a special right to liberty that the rest of us do not enjoy, where did it come from? It came from a decision in 1963 in an unemployment compensation case, a case in which Sunday observers could observe their Sabbath, but Saturday Sabbath observers would lose their benefits if they declined a job. And in that context, the Supreme Court, in a case called Sherbert v. Werner, which Steve mentioned, announced that this was unconstitutional. But Justice Brennan went further. He said he didn't rely on the inequality that was transparently on the surface of the case. He announced that anytime government interferes with someone's religious projects, it's behaved unconstitutionally unless it is justified by a compelling state interest test. Now, the interesting thing is, and this is the part of history that is quite crucial, and it's what Scalia was relying on. For the 27 years between Sherbert v. Werner in 1963 and Smith in 1990, for those 27 years, the Supreme Court routinely denied the claims of plaintiffs under the compelling state interest test. Now, this was quite shocking. During that period, as one scholar put it, the compelling state interest test was strict in theory and fatal in fact. If you measured a law against the compelling state interest test, the law would go down. That was the lesson of racial discrimination in the United States. But in this area, the compelling state interest test was strict in theory and feeble in fact. It never worked. For 27 years, the court ruled on behalf of constitutional plaintiffs under the Sherbert rule in two contexts, and two contexts alone. First, there were 3 other unemployment insurance cases. Now that's pretty remarkable. We basically had a constitutional rule which was only viable in unemployment insurance. And the other context was a case called Wisconsin v. Yoder, in which the Amish were given rights to make decisions about the last 2 years of their children's high school education, a right that had been very well established for non-religious people as well in 2 prior cases of the court, Meyer versus Nebraska and Pierce versus Society of Sisters. So for 27 years, the nominal rule was, if you are motivated by religion, you get privileges that none of the rest of us enjoy to disobey the law. Not a get out of jail free card applicable in all circumstances, but applicable in many circumstances. And under that rule, despite that notion and the compelling state interest test, plaintiffs lost time after time after time. And what Scalia said quite persuasively, for once he was clearly right, he said, that's never been our rule. And he was absolutely right. It was a rule in name for 27 years only. For the 75 years before, it had been a Reynolds versus the United States, a different rule. And it was never the rule that the court could live by. Now, why couldn't the court live by its own law for 27 years? And that's because the idea of a special religious autonomy is morally and constitutionally unviable. And I want to spend a few minutes explaining why the rule of Sherbert was not one that the court could live under, and that Smith recognized that. There are 3 reasons why a special form of religious autonomy is constitutionally unviable. The first is it's simply unfair. Let me set out a simple case. Suppose there are 2 women living across the street from each other in Richmond, Virginia. They both happen to be called Mrs. Campbell, and they both happen to want to run soup kitchens. And they want to run soup kitchens for the poor. And they are both barred by zoning ordinances of Richmond from running a soup kitchen in their houses. One of them is deeply religious and wants to run a soup kitchen because her God has told her to. The other says, religion doesn't enter this story at all. I just feel deeply compassionate for the tragic circumstances of adults and children in the most prosperous city of the world going hungry. So I feed people because they need food and deserve it. not because of my God. Now, the question is, does a distinction running in either direction between the two Mrs. Campbells seem fair? Suppose Richmond were to say, well, you can run a soup kitchen if you're religiously motivated, but not if not. Or suppose Richmond were to say the other. It seems to me patently unjust, indeed unconstitutional, to favor one Mrs. Campbell over the other Mrs. Campbell. And that's essentially, by the way, what the Supreme Court concluded in the two conscientious objector cases, Welsh and Seeger, when it couldn't live with a statute that said you have to have a belief in a supreme being in order to be a conscientious objector. And it said people whose views were very different, that didn't track any ordinary religion, were entitled to the statutory exemption to be a conscientious objector. And Justice Harlan, concurring in Welsh, said, let's be clear what we're doing here. We're acknowledging that the Constitution can't tolerate making a distinction between the religiously motivated person and the non-religiously motivated person. But a special claim of autonomy for religion assumes that that distinction is made, and it's unjust and unconstitutional. The second reason that the court couldn't live with the rule of Sherwood v. Verner is that it is in a very deep way incoherent. And its incoherence lies in the following. It's incoherent because in order to create a special privilege for religious belief, you have to be able to define religion. And the minute you define religion, you have created an orthodoxy. And when you create an orthodoxy, you are doing the worst possible thing for religious freedom. So any attempt to cabin a set of beliefs and say that these are religious is self-destructive. It's a little like, I don't know if this audience remembers Monty Python and the Flying Circus, but in Monty Python and the Flying Circus, they did a skit about a special weapon the English developed in World War I. And the weapon was a joke so funny that anyone who read it would die laughing. The problem in the skit was they couldn't find a way of delivering the joke to the enemy. They'd give the joke to a private in the English army to deliver to the enemy. The private would go into a little room and start reading it and laugh, and then hysterically laugh and collapse. It was self-destructive. Religious liberty, defined as a special claim of autonomy for the religious faithful, is like the World War I deadly joke. The minute you define religion in a way that makes the doctrine viable, you create an orthodoxy, and the orthodoxy is inconsistent with religious belief. And the third reason, which will take me to Fulton briefly, but only briefly, the third reason is that to grant a constitutional right to special autonomy for the religious faithful is to create a constitutional mechanism that undermines our most important constitutional project, which is equal membership in our political community. And Fulton is in many ways about that. I don't want to argue the details with Mr. Lorence, but I'm happy to if he would like. But in Fulton, the city of Philadelphia has taken responsibility to place foster children that it has typically taken out of unsafe homes, and to find appropriate families for the foster children for which it has clear responsibility. It has contracted with, at one point, as many as 30 providers. Now I think it's down to about 20 or 21 providers. And all of those are the recruit and provide families for foster children. Now, if you're a couple or an individual in the city of Philadelphia and you want to be a foster parent or family, you go to a website of the city of Philadelphia and it lists its 20 providers, and you choose those providers. And should you make the terrible mistake of being a same-sex married couple and choose the Catholic social services provider, which is without any warning listed as one of the providers in the city of Philadelphia's webpage, and you would go to them, you would be told, we will not process your application because we do not think that you as a same-sex married couple can possibly, in the eyes of God, serve as an appropriate family. So it's an extraordinary and treacherous idea that Catholic Social Services not only gets to live by its faith, which of course is true, not only gets to worry about its own placement, but gets to be employed by the city of Philadelphia as a provider. And that's all that's been denied. The city of Philadelphia hasn't told Catholic Social Services it can't place children, hasn't told them it has to do anything. It's just said, we won't pay you to be one of our providers. We won't contract with you to be a provider. My own view is that if the city permitted itself to contract with Catholic Social Services, it itself would be violating the Due Process Clause and the Equal Protection Clause, because the city can't discharge its obligations in an unconstitutional manner simply by employing a private provider. And that's exactly what is at stake in the city of Fulton. Now, city of Philadelphia. Now, we can talk about Fulton, but I think Fulton illustrates pretty vividly exactly what's wrong with the idea of religious autonomy. It's boundless. And the Catholic Social Services, unlike another Catholic agency, by the way, Bethany, in Philadelphia, which immediately complied with the city's requirement, Catholic Social Services will not service same-sex married couples. Fine. But it certainly does not have a constitutional right to be employed by the city. But that's the kind of aggressive claim that religious autonomy immediately gives onto. My worry isn't that it's aggressive, it's that it's undermining of the deep constitutional value of equal membership, which is the value that drove Obergefell versus Hodges, and is the value that the city of Philadelphia was in pursuit of. So to sum up, Steve, I don't think the rule of Sherbet v. Werner was ever really the law. I'm entirely on Scalia's side in that regard. And the court itself couldn't live with it for good reason. And the city of Fulton, I want to create a new city here. There is a Fulton, California, actually. The city of Philadelphia, I think, had a constitutional right and obligation not to contract with a discriminating provider, which is all it chose to do in Fulton. That's it.
Thank you, Professor Sager. And so I've given both of you an opportunity to talk about the merits of Fulton. I'm hopeful that you can restrain yourselves and limit yourselves to that, your arguments you've placed, and we can focus more on now some of the students' questions, some of which really do focus on the question of whether or not Smith should be revisited and how. And one of the first student questions asks the question of how do courts determine what qualifies as a sincere religious belief? I'd like to flip that question a little bit or tweak it a little bit, and I'll send it over to you, Mr. Lorence, first. But Professor Sager makes the argument that under the pre-Smith test, or if you are going to truly apply a true compelling interest test to a free exercise claim, that you actually, there's a problem then of having to define what a religious belief is. And isn't that problematic, and doesn't that create an orthodoxy? And the student's question, their follow-up question, actually touches on that. They say, for example, what obstacles do new and emerging religious groups face in proving that they hold sincere religious beliefs? So I'd love to throw it to you, Professor Lorence, and ask, how do you deal with that concern of having to define what is a religious belief? And does that undermine the test that is in the Religious Freedom Restoration Act and in various statutes? And then we'll give Professor Sager a chance to respond.
Yes, and the definition of religion has not been in litigation a major issue that oh wait, we don't know whether this is religious or not. That the place where it really comes up is in the sincerity of somebody's religious belief, even if they're bizarre, has never really been challenged. Like, do you really believe that? Except in situations of pretext. So, for example, in tax evasion cases where somebody sets up a fraudulent religious group where what's really going on is they're trying to evade taxes. They set up, their name's Bob, they set up the Church of Bob, and they donate all their money and try to take tax breaks, things like that. In some of the prisoner cases as well, sometimes that have very exotic religions, there's been some challenges as to whether the beliefs and the relief that they're asking for is pretextual. But so far, the courts have not defined it, and I don't think that they've really seen a need of to just wade into a theological morass as to what is religion and what is not.
Larry, go ahead if you'd like to respond shortly to that, and we'll move to another student.
I just want to say two things. One, there's a deep conceptual issue as to what religion is, and what form of intense and sincere commitment is religious. Is there any that is not? Now, in the conscientious objection cases, the court said, we're not going to make any substantive judgments. We're going to ask what roles this plays in someone's life. Now, that's fine, but that means that that which is religious is any deep and organizing commitment, including racism, including which, by the way, was invoked in the Brown era, the religious commitments against integration, just as we're now seeing the equivalent with regard to the LGBTQ community's statutory rights. If religion is any deeply held view.
Oh, you hit the mute. The mute.
You're still muted for some reason.
We're not hearing you.
I can't hear you, and I don't know why. You don't appear to be muted. Our host, do you guys have any control over what's going on his end? Did you bump a microphone or something by chance? You can't hear us either? No, we still can't hear you.
Mike, is there anything you can do on your end, or?
Professor Sager, I don't know if you can hear me.
Come back.
Yeah, that would be my suggestion.
It looked to me
Well,
like
I know he's not going. Should I say? I mean, I can have some response. One of the thing that he mentioned, and he didn't complete this argument, and which I wanted to ask him, and I hope that he'll get on.
I'm on now.
there he goes.
Oh, okay. Well, go ahead. Complete what your thought.
No, you go. Well, no, I think I forfeited well, no, I do want to say one thing that I think is important. I can tell you a context in which we will discover this question vividly, and it's right around the corner for us all. And I hope the court is aware of that if it tinkers with Smith. And that's with regard to vaccinations.
Yes.
We are going to discover suddenly a strong religious adversity among some to vaccinations, and exactly what qualifies as a religious adversity to vaccinations and not is going to put a lot of stress on this, not on sincerity, but on the very idea of what forms of intense beliefs and commitments are religious and what forms of intense beliefs and commitments are not religious. Sorry, go ahead, please, Jordan.
No, I agree with that. And I think it will also is government police power under the U.S. Constitution, a state's police power sufficient to order vaccinations. And they obviously protect a lot of people and all that, but there's a lot of people, both religious and non-religious, that have very intense opposition to it. And I think that you're right. and the coronavirus is only going to make this worse. One of the things that you said that I just want to respond to, because this comes up frequently, and I don't think it's a helpful argument in advancing the ball, of pointing to people that have had asserted racism. You know, I have religious beliefs and therefore I'm a racist, or, you know, I don't believe women should have the right to vote because of my ridiculous religious beliefs, or something like that. Because what it does is it basically says religious beliefs should not be protected. And so if somebody, the pacifist who objects to the military, to being in the draft, or the Muslim who says, you know, I want to wear my beard in prison and you're allowing an exemption already for medical, then they can simply say, well, you know what, if we grant it to you, then we're going to have to grant it to the religious racist and the religious person that denies, you know, women the right to vote. Where I think there's obviously a compelling state interest in these other instances, and they're not in the other. And so I don't think that it's like helpful to bring that up, that there's people that do that, because it means nobody gets religious protection then. So I just think the sort of the prejudicial effect outweighs the probative value of that kind of an argument.
I actually think that the parallels between religious claims on behalf of anti-miscegenation statutes and on behalf of Brown are directly analogous to religious claims not to conform with Public Accommodation Act claims on behalf of LGBTQ individuals. So I think the analogy is forceful. But you know, you've mentioned the prison context several times, and I think it's a great context. We have a special statute, our LUPA, which protects prisoners. But if you look at the prison cases carefully, what they represent is, in the totalitarian environment of a prison, then special concerns about religion really take on a form of an equality claim and treating people fairly. So I'm all in favor of special dispensations in prisons. I'm in favor of special dispensations in the military. Totalitarian, I don't mean this pejoratively, but environments in which the government is totalitarian, where every aspect of an individual's life is subject to regulation, like the military and like prisons, are a special case for religious exemptions, and largely equality notions will prevail in those contexts. So I'm totally sympathetic there. It's elsewhere that I think that this is both unfair, incoherent, and in the way, actually, for me, of Fulton or Masterpiece Cake Shop or other cases. I think it's a pernicious idea. And let me say, this isn't a new discovery. When in the wake of Smith, Congress took up the Religious Freedom Restoration Act, and there was huge enthusiasm for it on all sides, including the ACLU. My then co-author, Chris Eisgruber, who's been stolen by Princeton to be their president since, when Chris and I were arguing in 1993 that the Religious Freedom Restoration Act would bring us where we are now, and that it would be undermining of the capacity of government to secure equal membership for all of its citizens. And I think it is. I think fair exemptions for religion make perfectly good sense. Conscientious objection, Jordan, is a perfect example. Congress began by saying only those who have a belief in a supreme being get this exemption. The court, by misreading the statute, made it a generous commitment to anyone with sincerely and deeply held beliefs that fit the profile of conscientious objection. That's a perfect outcome, but it's not an outcome driven by a special concern for religion, but for a concern for religion and like commitments. It's a fair generous and appropriate standard, and one which takes care of the extreme cases that you want to argue me off of.
All right, let me get back to some of the student questions here. Appreciate your comments, both of you, on that. I'm going to combine two questions. One student is wanting to know, I think from a normative standpoint, we've got this tremendous tension in our society right now. It's a major factor in the culture wars between equal protection under the laws and folks trying to make religious liberty claims. Normatively, what would be the best rule for the court to adopt? And I'll just add to that, it doesn't necessarily have to be the court. For Congress or other legislatures, what normative rule could be adopted that might ease that tension? And to combine the second student question with this, one student is wondering, is it even possible to truly have a neutral and generally applicable law? So if that's the standard we're going to use to determine if a law is okay, is that even possible? If not, normatively, what else should we come up with? And Jordan, I'll let you go, and then Professor Sager can respond.
Well, a couple of things is that I feel the government can be coercive outside of the situations of the military and the prison. And I use those examples, but I don't think it's limited. Now, it may not be as coercive, but they definitely could do this. Now, you can imagine, now again, I'm just hypothesizing on this, but if the government said, we want to promote certain ideas, and so, every citizen has to say, Trump is a great president, or the war in Afghanistan is wonderful, or things like that, and if somebody has a religious base, I think there might be a compelled speech argument there as well. But there would also be, if somebody was motivated by religion, and they were the only people that should do that, they should be able to have protection from those types of things. I think the government can violate rights all of the time, and I think too that it is especially we were the litigants in Masterpiece Cake Shop. It was creating a message that he objected to. That Jack Phillips served all customers, including LGBT customers, but he didn't create all messages. In the Piggy Park situation with the barbecue stand, I think it was, there was no message being created unless you say him serving barbecue meat to African Americans communicated a message, which is very different than an actual message being communicated by a wedding cake or by invitations or by a wedding video or something like that. So I think that these types of objections, that what you're doing is, if you're basically saying, well, we can't define religion and this test is too onerous, is that you allow the government to have a prevailing orthodoxy and to impose it on people, and they basically have no recourse unless maybe a free speech or an equal protection. But if it's religious motivation, tough, you're just out of luck with something like that. And I think that's just giving way too much beneficent credit to the government not to abuse that kind of power.
I think this is a terrific question as posed, namely, what does a constitutionally attractive, morally attractive landscape look like? And I think that in general, one way to put that is, what view of religious liberty and free speech provides fair rules and regulations for religiously diverse people? That seems to me a really interesting and difficult question. I'll take a couple of stabs at it. One is, we have gone out of our way in our legal regime broadly, constitutionally and otherwise, to permit individuals to provide, in effect, enclaves of self-expression, self-realization, and belief. So that, for example, 45 states and many municipalities have public accommodations acts. Every one of those public accommodations acts makes general exemptions for clubs and special exemptions for churches. and what individuals do. And in my own view, the special exemptions for churches and religious institutions are just a specific instance of the special space created for clubs. The ministerial exception, which has created a great deal of autonomy for religious schools and their employment of not just ministers, but teachers who teach religion. I think the ministerial exception may be too broad, but the idea is exactly right. I think churches and religious institutions have a right analogous to secular clubs that if they were built the same way, to discriminate or make individual choices inside the religion, but not inside the society at large. The way we have pursued our pluralism is permitted people in their houses, their homes, their churches, their clubs, their minds, their speeches, the streets, to speak their mind and pursue their beliefs. But when they go into the marketplace and they become public accommodators, servicing everyone, we've imposed anti-discrimination principles. And when, for heaven's sakes, they're employed by the city of Philadelphia to do one of Philadelphia's jobs, then we impose anti-discrimination principles. And that notion, which is somewhat unique to the United States, has served us very, very well without a crazily robust notion of religious autonomy. The United States has been one of the most religious and most religiously diverse governments of any Western state. It's been a successful experiment, but it's based on pluralism by setting boundaries on where you practice your pluralism. And it's that boundary that I think is actually the solution to this otherwise seemingly intractable notion of culture wars. LGBTQ individuals aren't going to go anywhere. Hopefully their constitutional right to marry and to live their lives with equal dignity and stature isn't going to go anywhere. And no one is asking anyone to salute or not salute that unless they take themselves into the marketplace or unless they go to work for the city of Philadelphia. And if they do those things, then they should certainly abide by our constitutional norm of equal membership. And that boundary seems to me a viable one.
All right, thank you to both of you. We only have a couple minutes left, so I'm going to combine two more questions that I think are related. One is asking about how we think adding an additional quote unquote conservative justice to the Supreme Court will affect religious liberty moving forward. And the other one is asking about whether or not an originalist understanding of the First Amendment can help us resolve issues related to defining religion. So if you can combine those two questions, I'd appreciate it. The only caveat I would add is that I have been disappointed at I will say I'm not an originalist yet, but I have been disappointed at the caricatures of originalism in the media during the Barrett hearings. And so, when we talk about originalism, we talk about a public meaning originalist, which is what Barrett at least purports to be. So the question is, what is her addition to the Supreme Court? Someone who is a public meaning originalist, what is that going to do to the court? And does that help us resolve some of these difficult questions of defining religion and making religion, something that can function in a pluralistic society? Professor Sager, why don't you respond, and then we'll give Jordan the last word since you said he was representing the petitioners here. How's that sound?
That sounds perfect. And Jordan, thank you it's been a pleasure. Let me say, since these may be my last remarks, thank you for joining us. And thanks to the Federalist Society, since these may be my last remarks. I think we would want to distinguish two features of Judge Barrett's candidacy. One is her pretty thoughtful academic commitment to some form of original meaning, and the other is her own very deep and open commitments the religious aspects of her life. I think that her addition to the court may drive the court in the direction of a more full-blooded embrace of religious autonomy of a kind that I think is treacherous and have tried to describe. She won't do that alone, but she might tip that. It is a bit of a misfortune that the odd issue of religious autonomy has become so political on a left to right basis. If you think back to the history that Steve and I disagreed about, Justice Brennan, on my view, was the one who was mistakenly embracing religious autonomy, and Justice Scalia, who had the good sense to say, this is a constitutional anomaly and it's never been our rule. That's not true any longer. This issue now has become one of left to right politically. And I think Judge Barrett, in various ways, has signaled that her presence on the court might drive the court in what I think is a very wrong direction. Now, its connection to originalism or original meaning, I think, is mistaken. This is the wrong time to start this debate. But let me say that I think most interesting and important constitutional questions cannot be resolved by the original meaning of the text. And surely that's true about this question. There isn't enough content to the idea of free exercise or anti-establishment on the surface of the words to answer the really interesting and difficult questions about what composes free exercise. In my view, what composes free exercise is a robust and sensitive anti-discrimination principle. But I don't think you get that out of the words any more than you get what I've said is a kind of treacherous understanding of free exercise. So I don't think originalism will do much work, but I think Justice Barrett might.
I do not know in particular how she might vote if she's elevated, but one of the things that I would point out that she may add to this is that last term, there were 3 major religious liberty cases that were pretty robust in school choice and church autonomy and a right of conscience case in Little Sisters of the Poor, along with the Bostock decision defining Title VII sex to include sexual orientation and gender identity. So what we might be doing conceptually, what the Supreme Court may be going for, is that if there is change socially, the people who have the opinion that is, lessening need to feel protected and that they're not going to be crushed by this new prevailing orthodoxy. And I think that will generally help reduce tensions, because if somebody feels like their back is against the wall and they're being forced to compromise their beliefs, that's a problem. And that's why I think, and just to end on Fulton here, the city of Philadelphia upset a system that had been worked out spontaneously by the 30 groups or so that were in this, that allowed every same-sex couple to apply to be considered to be a foster parent. It had every kid taken care of, in terms of the capacity of the families that were there, and the Catholics had their religious beliefs protected. That sounds like a way to settle down and eliminate controversy and help lessen the tensions of the culture war. And I hope at least that Professor Barrett would have that in mind if she becomes Judge Barrett, and now probably Justice Barrett in the next few weeks. And thank you for having us.
Thank you to both of you. I assume now Kylie is going to take on over here. Okay, there she is.
Yes.
Thank you, Steve.
Thank you.
Yeah, thank you to Professor Sager and Mr. Lorence for being with us today. I think it was a really interesting discussion and really appreciate all of the insight. And thank you so much, Professor Collis, for moderating. Excellent job. And we're very happy to have you with us as well. So thank you, everyone, and have a great rest of your day. I think that just about does it.